Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on section 127. It has been seen in many cases that when the jurisdiction of the assessee is with some assessing officer and he also passes order under section 143 subsection 1 or section 143 subsection 3 or in any other section, and the assessee shifts from one place to another. In those cases, it has been seen that when the assessee shifts from one place to another, then the assessing officer of the another place, of the second place, issues the notice for doing assessment without the transfer of the file from one place to another under section 127. The issue before the Honorable Punjab and Haryana High Court through a writ petition was that if the file of the assessee has been transferred from one officer to another without section 127 order, so whether in that case the assessment based on the notice issued by second assessing officer is valid in absence of notice or order under section 127. This issue has been decided by Punjab and Haryana High Court in the case of Lieutenant Colonel Paramjit Singh versus Commissioner of Income Tax and another, and this case is reported in 220 ITR at page number 446, and the date of the judgment is 13th March 1996. The present case relates to the assessment year 1988-89. In the present case, the assessee was living in Pune. The assessee filed the return of income. The return of income was processed under section 143 subsection 1 and some tax was computed by the assessing officer which was duly paid by the assessee. After that, the assessee shift from Pune to Jalandhar. The assessee do have some matrimonial disputes, and due to that matrimonial disputes, the in-laws made a complaint in the income tax department that there is some income escaping income. There is some undisclosed income, and due to which the assessing officer of Jalandhar issued notice to the assessee under section 148 for doing the income escaping assessment under section 147. The assessee challenged this notice in the Punjab and Haryana High Court through a writ petition. First of all, the department pleaded that whatever the apprehensions of the assessee are there, that can be dealt during the assessment proceedings. But when the court heard the writ petition of the assessee, the court was of the considered view that in the present case, since the matter goes to the root of the matter and the case of the assessee has been transferred from Pune to Jalandhar, and it is apparent from the record that there is no section 127 order, so in that case the writ petition of the assessee should be admitted. The court said that in the present case, since the revenue is not able to produce the 127 order, so the assessing officer do not have any jurisdiction to issue the notice under section 148. The court said that the officer who completed the earlier assessment do have the jurisdiction to issue the notice to the assessee, since in the present case the jurisdiction was with the assessing officer of Pune and he has not issued the notice under section 148, but the notice has been issued by the assessing officer of the Jalandhar, so it does not make any difference that the assessee has transferred from Pune to Jalandhar. Even in that case, the notice under section 148 can be issued only after a valid transfer order under section 127 has been passed for the assessee. Friends, this case is very important because in a number of cases, especially in the regime of faceless, it has been seen that the file of the assessee is transferred from one place to another. The PAN number is lying with some another assessing officer who do not have the jurisdiction of the assessee. So this is a basic before issuing a notice to assess the assessee, that assessing officer should have the jurisdiction of the assessee. This case squarely applies in all those cases where the assessment has been done without having valid jurisdiction. Friends, although this case is 30 years old, this case has equal importance in the present income tax proceedings also. At the end of this video, once again I am repeating the name of the case. The name of the case is Lieutenant Colonel Paramjit Singh versus Commissioner of Income Tax and another, and this case is reported in 220 ITR at page number 446, and the date of the judgment is 13th March 1996. Thank you, friends.